This court is now in session. The Honorable Laura Livingston presiding.
Good morning, everyone. I'm Laura Livingston. I am a retired state district judge in Travis County. And since my retirement, I have agreed to sit by assignment and on this case have been assigned to this cause number. I want to go through some preliminary information, get introductions, and then we'll begin with our proceedings. First, let me call cause number CV23005479. Estancia Villas versus, and I'm not sure how to pronounce the last name of the defendant. I understand his first name is Alan. Is it Way? Tell me how to pronounce your last name. You're muted. You're muted, sir.
There we go. Can you hear me now?
Yes. What?
Yeah,
How do you
Alan
pronounce your
Way?
Way? Okay,
Yes, ma'am.
perfect. That's helpful. Thank you. Okay. Let me make some preliminary comments. I am sitting by assignment, as I mentioned, because I'm a retired district judge. I've been assigned by the presiding judge of the 3rd Judicial Region to this case. Initially, I was told that I was going to be hearing a motion to recuse, and now I understand that the judges in the cases have voluntarily, or all of the county court at law judges for which this is a county court at law case, have voluntarily recused. So it's my understanding that that matter is moot. So that means now I'm going to be assigned to hear the merits of the case. That's my understanding. If that's incorrect, you can offer correction to that in just a minute.
Yeah, that's incorrect. There was a motion to recuse the judge.
Hold on. I'm going to just kind of set the agenda, and then I'm going to come back to each one of these. So that's the first thing on the agenda that I want to clarify. It's my understanding, and I have been assigned by the court order to hear the merits, and I've been given jurisdiction until the court loses its plenary power. So I'm doing whatever it is that's going to be involved in the case. That's my understanding. And so if you have a different understanding, we can get to that in just a minute. But that's sort of item number 1 on our agenda. Second thing I want to point out is that I received a phone call on my personal cell phone number a few weeks ago. And I don't know who made the phone call because the person on the phone never gave me their name. So I don't exactly know who I spoke to. I just want to disclose and report to everyone involved that I received a phone call and from a gentleman. We did not discuss the merits of the case because when the gentleman called and started saying he was calling about a cause number and he started saying CV, and we never even got to the whole cause number, I interrupted the caller by saying, "Whoa, stop. I think you may have the wrong number." That led to us, between us, a conversation about, I couldn't understand why somebody might be calling my personal cell phone number. I did some investigation, learned that a mistake was made on the part of the county clerk's office. When the county clerk's office sent out information to the parties, they included information that was meant to go to the county auditor, not to the parties. That information had my cell phone number on it, and so I got a phone call. Whoever it was did not tell me their name, so I don't know if it's y'all or not. I'm assuming it's someone involved in this case, only because they started by saying CV something, and to date, this is the only CV cause number I've been assigned in this year. So putting 2 and 2 together, that's my understanding. But as I said, we did not have a substantive conversation about the merits of the case because I stopped the caller by saying, we have these ex parte communication rules and you can't talk to the judge without the other side being present, blah, blah, and so forth. And then I've followed up at the clerk's office to find out how in the world my personal cell phone number might have been given out, and they confessed mistake. And so now there's training involved in all of that. So not a problem, I don't think. As I said, we did not discuss anything related to the substance. Those are the 2 things that I needed to disclose, and so start with you. And then the third thing, of course, on the agenda will be the merits of your lawsuit. And let me tell you what I understand about that so far. There was an eviction in the JP court that led to an appeal from the decision from the Justice of the Peace. The appeal filed in county court is what is before the court today. So by way of agenda, those are kind of the really 2 things on the agenda. The third thing was just my disclosure about the phone call. Now, with all of that having been said, let's begin with introductions. Who is here on behalf of the plaintiff, Estancia Villas?
Good morning, Your Honor. Erin DuBois on behalf of the plaintiff Estancia Villas, LLC. I also have my client's representative, Ms. Jennifer Alvarado, as well as Amanda Cantu. They're both with the property.
Let me just write those names down. Jennifer Alvarado and, I'm sorry, what was the other one?
Amanda Cantu.
And Ms., is it DuBois, B, like B-O-Y, but, okay.
Yes.
Your counsel for Estancia Villas and Ms. Alvarado and Ms. Cantu are the client representatives, is that correct?
That's correct, Your Honor.
All right, very good. And for the defendant, Mr. Way, you could just state your name for the record, please.
Hey, I'm Alan Way, representing myself pro se in the countersuit as counter plaintiff in this case number.
All right, let me make a note of that.
And I did want to get a little clarification. There was a motion to recluse the judge. He went ahead and signed it. 1 or 2 days after that, there was another judge who additionally signed it, is why the assignment, I guess, was assigned to you. And by the way, I've already spoken to I think it was a 200 or 300, some sort of administration, but the judge who assigned you, I've already spoken to him about the merits of the case too. So I just wanted to go ahead and clarify that. And then I was
sorry, back up. What judge are you talking about there?
Whichever judge assigned you to this case, I've already spoken with him about
Okay,
last week.
I have not spoken to the judge who assigned me to the case, so that's helpful to know. Okay, very good.
Yeah. And then I just wanted to make a note as far as the reclusal goes. We've already there's multiple motions that have been filed into the case. I don't know if you just want the counsel of appearance for right now, but I'm ready to basically state my claim.
Okay, so the way it'll work today, now that we've kind of dealt with the preliminaries, is that I'll hear opening statements from Ms. DuBois and then from Mr. Way. I do that in that order because Ms. DuBois represents the plaintiff. They're the folks who kind of brought the eviction case in the first place. So I'll hear from them first, and then I'll hear from Mr. Way. But because Mr. Way has a counter petition, what I'll do is ask Ms. DuBois to sort of lay out her client's position, and then I'll ask Mr. Way to lay out his client's position. My thought is that in order to make this the most efficient proceeding, Ms. DuBois, you can anticipate Mr. Way's concerns on his counter petition and just tell me everything related to your side of the case. Mr. Way, in both responding to the plaintiff's claims, but also advancing your own claims, go ahead and just tell me everything you want to tell me about your side of the case. Instead of going, 1, 2, 3, 4, back and forth, we'll just do everything they want to say, everything you want to say, and then, we'll hear evidence after the opening statements are over. And then we'll hear after the evidence phase is finished, and I've considered all the evidence, if that's live testimony, any witnesses you may want to call, any documents that might be admitted into the case. Once we've heard all the evidence, then I will hear closing arguments. And again, we'll just do that from the plaintiff, the defendant, and then because of the way the rules are set up in our civil cases, I would hear from the plaintiff, the defendant, and then because the plaintiff is the plaintiff, they also have the right to close. So it'll be Mr. Boyd, Mr. Way, and then Mr. Boyd, and that's it. So that's kind of sorry?
Yeah, I'm sorry. I just wanted to mention before we go back and forth with the argument, the assignment that you guys are, or that you're on right now, specifically, it also mentioned in that order that all of my other cases in Travis County, you're going to be handling at this point in time. Like, I literally do not have the option right now to even petition or do anything as far as the is.
Hang on a second. I'm not aware of that.
It's in your order.
Okay, I hear you. What I'm saying is that I'm not aware of other cases at the moment being set for trial other than this one. So if I'm to hear some other ones, we need to get those scheduled for a hearing, because today I'm only dealing with this one cause number.
For sure.
I'm happy to hear. Hang on a second. I'm happy to hear other ones, but I don't have those scheduled at the moment. And so we need to work out
one at a time.
Yeah, and if they involve the same parties, then obviously y'all could coordinate and we can, set them on the same day maybe. and just pick one day and kind of knock
Yeah.
them out, if that makes sense to you all. But I'll leave that to you guys because I don't know how much time you have available to hear the other cases and so forth. So today, I'm just going to handle this one, and I would ask you and whoever is on the other side of your other cases to get together with the clerks and with Ms. Burks, Angela Burks, and schedule those other matters, because right now I don't have anything scheduled except for this one.
Copy that. And just to add a comment to that, this is in fact a hearing because I've had a demand for a jury trial for forever. And that's actually the preliminary reason why Todd Wong, along with his bias, we had a motion to recluse him. This is supposed to be a jury trial. So this is just a hearing.
So let's clarify then what we're doing today, because I understood that this was going to be a trial on the merits.
No.
Mr. Wade, hold on. So let me point out some other sort of preliminary things and procedural things. Miss Duet that you see on the screen there is our court reporter. She's taking down everything we all say.
Perfect.
She takes down what I say. She takes down what everyone else is saying. And in order for her to get a clear record, and in order for her to hear what everyone is saying, we must speak one at a time. So things like perfect in the middle of what I'm saying makes it hard for her to follow and write down everything. So if you don't mind, Mr. Wade, just wait until I call on you or call on Mr. Boy or something like that. Now, the one exception to that, of course, is if somebody during the evidence phase has an objection, you do need to say objection. That interruption is perfectly okay and necessary. So please feel free to say objection during the evidence phase of the trial. But during opening statements and closing arguments, or just a question and answer phase between the lawyers and the judge, we really need to speak one at a time so she gets to hear everybody, so that everybody else can hear everybody, and that we're not interrupting, and she gets a very clear record for appellate purposes. Okay?
Okay.
All right, good. All right. Now, let me start then with adding to item number 4 on our agenda, which is sort of related to number 3, the merits of the matter and all matters being assigned to me, the jury demand, because
Your Honor,
I understood that we were just hearing the merits today. We're going to hear the merits of the case today, but let's get that clarified. Mr. Boyd, let me start with you. What is it that you think is set on the docket for today?
Your Honor, a trial before the court on the merits of the eviction is set on the docket today, as well as plaintiff's motion under Texas Rules of Civil Procedure 510.9 concerning immediate possession of the property. And Your Honor, to clarify on the jury demand, this case was initially set for January 17 of 2024. The courthouse suffered water damage due to the freeze that previous week. And so that setting had to be removed, and then it was set for February 20th of 2024. The defendant did file a jury demand on, Your Honor, Mr. Wee, I believe, is recording this proceeding.
Is that not okay?
No, Mr. Ware, you may not. It looks like you.
Didn't you say it was live recorded?
No, it's being streamed live. So if you want to look at YouTube, you can. That recording will be taken down when we're finished.
Okay, I'm sorry. I apologize.
Well, it won't stay up long. So if you want it, you should look at it quickly. But we're live streaming under the rules because we want to cooperate with the open courts provision of our law. But you can't individually record the session.
I apologize.
Okay, no, don't worry about it. Go ahead.
Your Honor, the defendant filed a jury demand on the 11th of January. The court, Judge Wong in County Court 1, entered an order on January 26th denying the demand for a jury trial of 12 jurors. This is in accordance with the Texas Rules of Civil Procedure 216. The jury demand was not timely. It was not within 30 days of the trial date. And it was also in county court, we have juries of 6. And so the court properly denied Mr. Way's jury demand.
Okay. Well, I'm happy to take up that request today because it is, well, no, that wasn't from the JP order. That was Judge Wong that made that choice.
That's
That
correct,
made-
Your Honor.
that
And this was on
choice, right?
January 26th
So
of
that's not
22.
really, sorry, that's not really part of the appeal from the JP court. He didn't demand, did y'all have a jury trial in JP court?
No, Your Honor.
Okay, so the jury demand came only after it had been appealed to county court?
And after the case was set and it was not timely.
I see. Okay, and Judge Wong made the decision on the denial of the jury trial.
That one's
I'm
gonna
just
be
looking for-
complicated. I have it. It's gonna be complicated to find because it's an email. When this happened, I immediately sent over documents of the email to the court, CC1, CC2, county clerk, everybody was involved that saw it. I sent images to everybody so they could see it. There is no
Okay,
excuse.
so let me just clarify. I think what I'm hearing you say is that you emailed documents, including your request for a jury trial to people, but it wasn't actually filed in the court file. Is that correct?
What I'm saying is that the means that they were accepting my documents, answer subpoenas, etc., through the filings, because I'm pro se, it's the same channels. The only reason why you would ask for a e-filed stamped copy is if I e-filed. And the reason why I have to e-file in the first place is because they changed it for pro ses, and everybody now, as of 2024, needs to file e-file. So I went to jail based on the same merits of the case for some nonsense that I have to explain. And then Erin, she can't even provide a notice of the trial prior to the 17th. She does not have that. There is no notice. I went to jail and came out and they started lying and doing a bunch of stuff.
Hold on, we're
Yeah,
moving on.
I'm
with
ready.
the conversation. Yeah, so stay focused with me on the jury demand. I just want to clarify so I'm clear and so we have a clear record.
Mhm.
You emailed
Yes,
lots of people,
exactly.
including people at the courthouse and opposing
Everybody.
counsel. You emailed documents to folks.
You got it.
But you didn't walk over to the courthouse and file it physically. You didn't electronically file it through the e-file system before January 11, 2024, but you sent it by email to a whole universe of people. Is that right?
Yeah, and I wait my turn.
Okay, no, I that's helpful because now I understand sort of the difference in terms of what you think people actually knew versus what was actually in the court file. And that's super helpful. That's helpful. Okay. All right. So now I understand, Ms. Du Bois, what I'm hearing Mr. Way say is that despite maybe not having been e-filed through the e-filing system in January, before January 2024, that Mr. Way sent you and others an email in which he included a request for a jury trial. Is that correct?
Your Honor, I have nothing from Mr. Way prior to January 11, 2024, requesting a jury. The court's file has emails, other subpoenas, things that were filed in the case in January of 2023. Nothing in my file or the court's file, when I'm looking online at the Odyssey Registry of Actions and the documents, I have not seen any jury demand, but for the demand that was sent on January 11, 2024.
Okay, well, he's already told us that there wasn't one filed before then, other than things he may have emailed, which is different
But
from
Your
filed.
Honor, there are filings.
But you're saying you
There
never received one before then.
That's correct. And there are filings from Mr. Way prior to January 11. There are several subpoenas that he had mentioned. There's emails. There are things in the court's file prior to that date. And I am not seeing any of those things indicating any jury demand. I did not receive one, and I do not see one in the court's file.
Well, I understand that Judge Wong reviewed all that prior to his decision denying the jury trial on that was filed in the court file on the 11th. I just wanted to make sure I understood Mr. Way's position and what he sent and who he sent it to and when he sent it, because all that's helpful and information and important information for me to have just so that I can understand how we got to where we are today. Okay, I think I got it. All right. Mr. Way, I'm going to move on because there is no indication in the jury trial, and I've looked at documents that Ms. Burke sent to me by email that were PDF folders of pleadings and so forth. And as I understand it, there was nothing in the court file, although I appreciate what you're saying is that you sent things to all these people. There's a dispute about what Mr. Boy received or didn't receive. I don't have to resolve that dispute because I do have to go by what is actually filed in the court file. So I'm not going to overturn, not that I have the authority because that's an appellate point. So I can't really overturn what Judge Wong did with regard to the denial of the jury trial. What I can tell you, however, is that all of that is on the record. All of the court filings are in the record. And so to the extent that you don't like whatever the outcome might be today, if you don't like that, you have the right to appeal that decision, as well as the right to appeal Judge Wong's decision not to grant you a 12-person jury back in January. So you have that as an appellate point, and that's one of the reasons why I wanted to walk through all the steps and stages so that we have a clear record of what happened, what you did, who you sent it to, what everybody says they received or didn't receive, and then we've got the court file so that the appellate court above me can then look at all of that and say, okay, here's what happened, and they can decide whether or not Judge Wong's decision to deny the jury trial was correct or incorrect. He's made that decision, and that's the law of the case at the moment. So I'm not going to stop the proceedings and go find jurors. I'm going to proceed to the merits, but understand, Mr. Way, that you do have that opportunity to complain about that at the appellate level.
For sure.
That record would be in here. Does that make sense? Okay.
I hear what you're saying. Carry on. I just want to say that on number 4, the merits of the case would circumvent your decision. So I can't speak right now. I'm gonna let Erin just continue and just say whatever she's got to say. And when it's my turn, you guys please give me the same respect. But I'm ready to go.
Okay. All right. So we'll proceed. January 2024. I'm just making my own notes about that, what we're doing so far. All right. So I think we've done everything on our agenda for the moment, except get to the merits of the case. And as I said, the way that that will work is as follows. Ms. DeVoy will go first with her very brief opening statement. And both Mr. Way and Ms. DeVoy will have just a very few minutes to kind of outline, not put on all your evidence, just what's the case about? I understand it's an eviction, so we don't need to spend a lot of time explaining that. But what is the decision that I have to make? That's what I'm looking for in the opening statement. 1 or 2 minutes max on opening statements for both of you. 1 or 2 minutes on opening statement. Now, then we're going to proceed to the evidence phase, and then Ms. Way will call her witnesses and put on her evidence. Then, or Ms. DeVoy, sorry. Then Mr. Way will call his witnesses and put on his evidence, and then we'll hear a little bit longer time for closing argument. Because you get to argue, you'll have more time to do that. But opening statement, couple minutes on what does the plaintiff want, what does the defendant want, what does the counter plaintiff want. Mr. Way has both the role of the defendant, but also the role as the counter plaintiff. And then Ms. DeVoy, you have the role as the plaintiff and also the counter defendant. So what does everybody want at the end of the day? What is the ruling you want the judge to make? That's really the point of these 1 or 2 minute opening statements. Ms. DeVoy, you may proceed first.
Judge, real quick. So I just need 1 second. I need to plug in my computer. I didn't realize I didn't have it plugged in. So I need 1 second.
All right.
Let's make sure we have everything on the record, please.
Please don't talk. Wait.
Yeah, so when you say things like that, she can't take it down. So hold on a minute until she's ready, and then she can take it down.
All right, I'm ready. Thank you.
All right, Ms. DeVoy, your opening
Honor,
statement.
Before we proceed on the actual merits of the eviction suit, I would like to present plaintiff's motion, Estancia Villas LLC's motion for immediate possession under Rule 510.9C. We did file the notice of rent default and request on January 9 of 2024.
All right, for everyone's benefit, if you could please just explain
Of course, Your Honor.
the consequence of your request so that Mr. Way understands exactly what you're asking and how it relates to what we're doing today.
Of course, Your Honor. So as the court is aware, this is an eviction. It was appealed from the Justice of the Peace Precinct 3 here in Travis County. Judge Holmes in JP Court entered judgment on November 16. The defendant, Mr. Way, appealed that judgment by filing a statement of inability to pay under Rule 510.9C of the Texas Rules of Civil Procedure. However, that rule, 510.9C 5B1, does require that the defendant, within 5 days of filing that statement of inability to pay, deposit 1 month's worth of rent into the court's registry, that being the Justice Court's registry. And if they fail to do that, then the plaintiff is entitled to request a writ of possession. Mr. Wade did not make a payment into the Justice Court registry. However, the writ request in JP Court was not issued for reasons unknown. On November 28, after the Justice Court case was docketed in the county court, Mr. Way had continued responsibilities to pay rent as it becomes due into the county court's registry. That's under Rule 510.9C 5B2. Mr. Wade did not make a rent payment into the county court's registry by December 6 of 2023, which is required under the rules, as well as the Texas Property Code. Mr. Way also failed to pay any rent into the county court's registry for the month of January, which would have been due January 6th. In addition, no rent has been paid into the county court's registry for the month of February 2024. Again, an amount of $1,356, which is the monthly rent, would have been due at the Justice Court level, as well as the county court level on January 2020, in January 2023, would have been due January of 2024, February of 2024, as well as December of 2023. No payments have been made. Therefore, the plaintiff in this case is entitled to an immediate writ of possession under Texas Rule of Civil Procedure 510.9C.
All right. Mr. Way, let me first ask just a factual question, and then I'm going to let you respond to her request. The factual question, again, this is just a yes or no question. Have you made a payment into the court registry, either the Justice Court or the county court, of any money whatsoever? In what amount? And if so, in what amount did you make it? So
not
first,
to the Justice Court, not to the county court.
Okay, so you've made no payments.
$0, $0 and 0 cents.
Okay, all right. Now, if you would like to respond to her request, this is your opportunity to respond only to her request for immediate possession only. Just that part of it.
So they draft a petition. On the petition, literally they say that they have the exact amount that they claimed in rent. And I have a document. It's time and date stamped. They went there and they said that, hey, I have the exact amount claimed. They next proceeded to attempt to evict me for right of possession only while having all the rent. So literally the moment that they evicted me and passed the petition, they had already
Your Honor, I'm going to object to Mr. Way's testimony right now. This is not the merits of the actual eviction.
So
if he's to respond.
Stop.
You can calm down right quick.
Stop. I got this, Mr. Y. I got it. I don't take what he's telling me as is testimony. He's not under oath. I've not sworn him in. He's not giving me testimony, and because he's representing himself, he gets to make argument in response to your request. But let's be clear, what he's telling me is not evidence, will not be considered as evidence, because he's not yet been sworn in. He's not giving me testimony under oath. So now, I'll overrule that objection then, Mr. Boy. However, Mr. Way, let me ask you to focus, because I'm only asking you to respond very briefly to her request. I'm assuming you want me to deny her request. Let's start there, correct?
Yes.
All right. And my question really is more in the nature of a response to her legal argument.
Exactly. I got 30 seconds.
Yeah, just to be clear, what she's saying is, under the law, she's entitled to this, her client is entitled to this writ of immediate possession because you have not, under the law, paid into the registry of the court your monthly rent as it became due in the court. So she's saying you didn't pay it in December, you didn't pay it in January, and you haven't paid it in February. And because you failed to make those payments into the registry of the court, she says she's entitled on behalf of her client to the writ of immediate possession. My question is, since you've told me you've not made any payments, my question is, why is her legal argument incorrect?
Perfect. 4 points. Original petition. 1, they had already claimed all the rent at the time they filed the petition. It's a document that I'll show you in the exhibit later. The next thing is they're not suing for any attorney fees or applicable attorney fees. The third thing is they're not suing for any unpaid rent. The last thing is they were only suing for right of possession. I only appealed the decision because they didn't have any merits to evict me in the first place. Now, let me get to my next point. The fact that they were only suing for right of possession, and I confirmed this with the judge, and literally there's 2 documents where they try to change it up last second. I wasn't required to pay anything because my statement of inability to pay was substituted for whatever document in conjunction with them not requesting any money for rent. So the fact that they only asked for right of possession, and you can confirm this with the JP court, and I also have documentation I'll show you later. That's the reason why I'm not entitled to pay any rent while we're debating and civil litigating right now.
All right, thank you. Ms. Du Bois, your response to his, or your reply rather to his response.
Your Honor, my client is seeking possession of the property as well as back due rent in this case. He filed an appeal on a statement of inability to pay rent. There's been no payments into the registries of the court. The rules require that the court issue an order entitling my client to possession and immediate possession. So this is a non-payment of rent case, Your Honor. My client is seeking possession of the property as well as rent. Mr. Way, by filing that statement of inability to pay, had a continued duty to pay rent to the court's registry and failed to do so. So my client is entitled to a writ of possession.
All right, thank you both. I'm going to hold my decision on this issue until I've heard the rest of the case. So I'm not going to make a ruling on it at this time. I want to hear the rest of the argument and see what the evidence shows, and then I will make a decision on the request related to the immediate writ of possession. I'll save what I think about that until that time. So let's move on. I'll carry this forward as we continue the hearing on the merits and move to opening statements. Again, 1 or 2 minutes just on what it is your request for relief is, because I already understand the nature of the case is an eviction. I understand there are issues related to both rent and possession, and I understand more now than I would normally have in an opening statement. So very briefly, please give me your opening statements, beginning with Ms. Du Bois.
Yes, Your Honor. Again, this is an eviction based on non-payment of rent. My client, Estancia Villas LLC, is seeking possession of the property located at 1. My client is seeking an award of back due rent here today, and the evidence will show that Mr. Way has failed to pay rent beginning September of 2023. The evidence is going to show that my client has a superior right to possession of the property, and that they are entitled to their reasonable and necessary attorney's fees here today. That judgment for the back due rent owed through February of 2024 and their costs of court.
All right. Thank you. Very briefly, Mr. Way, your response just to the, not your response rather, but your own opening statement, both in connection with your defense of the claims against you, as well as your counter petition against them. But very briefly, just a couple of minutes on opening. Basically what I'm listening for is, what do you want the court to order at the end of the day?
I just want to take 5 seconds to point out Aaron's body language.
No, you don't get to do that. No, you don't get to do that. You get to give me your opening statement. You don't get to comment on appearance.
I can do the opening
Excuse
statement.
me. Yeah. We don't make personal attacks on people. I'm not gonna let anybody do that to you, and I'm not gonna let you do that to anybody else. So no comments on anybody's personal appearance or anything else. Just your opening statement, very briefly.
Yes, ma'am. So I was evicted on November 1st. They had filed a petition. There's multiple documents on file, but basically, again, let me reiterate those 4 points. They had sued me, and on November 1st, I was up to date on rent, and I can show you the document. They're not suing me they literally have the document signed. as an authorized agent saying that they had claimed rent. I wasn't violating the lease. They weren't suing for any unpaid attorney fees or unpaid rent. And then on top of that, like, basically what I'm trying to get at is the merits at the JP level didn't have any merits. There was no cause to evict me in the first place. The only reason why I appealed was because they sued me for right of possession and won that. But I'm actively suing 6 departments right now because of how they've been handling the cases. Currently, there is some very nasty stuff going on in Estancia Villas. Like right now, they've already updated all the smart locks. They've been monitoring me. The authorized representative.
Mr. Way, hold on. Let me break this down a little more basically. I understand that for the reasons you've already articulated, you want me to deny their request, correct?
For right of possession, absolutely.
All right. Now, secondly, you have a claim against them. My question is my question's 2 questions. First question is, what is the claim? That is,
Perfect.
what is the cause of action you're suing them for? And second question, what is the relief that you want? Like, what do you want me to do about it? So
I apologize. Here it goes. It's a criminal conspiracy, child grooming, unlawful use of criminal instrument or mechanical security device.
Slow down. I need you to slow down. Slow down. Miss Duet is taking it down in shorthand, but I'm taking it down in longhand. So
I'm sorry.
down. I got criminal conspiracy. What else?
Child grooming.
Okay.
Unlawful use of a criminal instrument or mechanical security device.
Okay, go ahead.
Unlawful interception, use, or disclosure of wire, oral, or electronic communications.
Okay.
Unlawful access to storage communications.
Okay.
Trafficking of a person.
All right.
Continuous sexual abuse of a young child or disabled individual.
All right.
Indecency with a child.
All right. Anything else?
Yes, invasive visual recording.
Okay. Anything else?
Yes, unlawful disclosure or promotion of intimate visual material.
All right.
Sexual coercion.
All right.
Unlawful electronic transmission of sexually explicit visual material.
Okay.
Aiding suicide.
Okay.
Theft.
Okay.
Deceptive business practices.
What else?
Fraudulent destruction, removal, or concealment of writing.
Okay.
Exploitation of a child, elderly individual, or disabled individual.
All right. What else?
Breach of computer security.
Okay.
Electronic access interface.
Say it again. Electronic.
Yep, PC 33.022. Electronic access interface.
Interface.
Yes.
Thank you. Anything else?
Yep. Electronic data tampering.
Okay.
Unlawful decryption.
Okay.
Improper influence.
Okay.
Witness tampering. Tampering with the witness. Probably the same difference.
Okay, go ahead.
Failure to stop or report aggravated sexual assault of a child.
Okay.
Abuse of the official capacity.
Okay.
Official oppression.
I'm ready.
Misuse of official information.
Okay.
Harassment.
All right.
Stalking.
Okay. What else?
And there's another one is a 71.02. It's a RICO charge. Racketeering to influence organized corrupt organizations. I said that correct.
All right. And so is that all of the causes of action that you've brought against them in your countersuit?
That's my countersuit right there.
All right. And what are the damages? What is the ultimate ruling that you want from the court? And what are you seeking in connection with those causes of action?
My proposed order of judgment is 200 million and criminal charges be pressed. It's the motion is why there's a motion to escalate to a criminal court. Because this is not civil.
Slow down. Let's do damages first. You're requesting $200 million.
200 million. Let me get back to your screen so I can see you. Sorry.
I just want to make sure I understood the number correctly.
Yes, ma'am.
Okay. And anything else that you're seeking in terms of the relief you seek today? You said $200 million in damages, and there was something else.
Yes, criminal charges be prosecuted against the individuals that were involved as accomplices.
Sorry. Let me just be clear. I want to clarify. You're asking me to order that some prosecutor charge them with these things? Is that what you're saying?
Well, initially it was a motion to escalate, seeing as how there's criminal charges, we need to go to district. But if you what you're talking about,
asking you what you want me to do. What do you want me to order? That's what I'm getting at. You want me to order $200 million be paid to you, and you want me to order somebody to do something related to criminal charges. I'm just trying to clarify what that something and somebody is. Or might be.
I want criminal charges pressed against all of the representatives in estancia villas as far as management goes.
Okay.
All of them that were involved.
So that's what I'm clarifying. You want me to order the DA to go prosecute them in criminal court?
Yes, and investigate estancia villas. I want an investigation open.
Trying to clarify what you want me to do. Anything
I
else
can
you want me
reiterate.
to? No, I don't want you to repeat. I want you to just tell me if there's anything else. I understand you want me to do two things. Well, really three things. One, you want me to deny their request against you. Two, you want $200 million in damages for these causes of action you have spelled out. And three,
Yes.
you want me to order the DA to investigate them and file criminal charges against them.
Got it. That's
All
it.
right. Is there anything else that you're seeking today?
Not for the proposed order of judgment. Deny
Okay.
them, 200 million, investigation, criminal charges pressed.
That's helpful. Thank you very much. And thanks for your opening statements. Let's move on to the evidence phase of our proceedings. Ms. DuBois, you may proceed first with your first witness.
Thank you, Your Honor. I do want to bring to the court's attention Texas Rules of Civil Procedure 510.3E. There are no counterclaims in eviction suits. Those are specifically barred for a number of reasons. Outside of that, Your Honor, I don't think the court has jurisdiction to hear Mr. Way's counterclaims.
All right. I'm aware. I
Okay.
want Mr. Way to have his day in court. I want him
Understand,
to
Your
get
Honor.
out everything that he wants, and I want to understand what he's asking for. And so, like with your earlier argument on the writ of possession, I'm going to hold on to your request in connection with his counterclaims until we get to the end of the proceeding, when I feel like I have heard everybody, that everybody's been heard, that everybody's position has been understood and respected. And then at the end of the day, I'll make some decision after I sort it all out. But I can't really do that until I've heard from everybody. I want to hear from everybody. I want everybody to have an opportunity to tell me their story, tell me what they're complaining about, tell me what the other side's, what their response is to the other side's complaints. And I want to know what everybody's got on their minds before I make any decisions. Okay?
Understood, Your Honor.
All right.
Your Honor,
Now, you may call your first witness.
thank you, Your Honor. Plaintiff calls Amanda Cantu.
Ms. Cantu, if you would raise your right hand, please. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Thank you.
And if you could just state your name for the record, please.
Amanda, thank you.
All right, Ms. Cantu, your audio is a little bit hard for us to hear. If you could just get a little closer to the microphone, that would be helpful to me and maybe to the court reporter and to Mr. Way as well. just get a little closer to that microphone. That'd be helpful. All right, very good. Ms. Du Bois, she stated her name. You may proceed with your questions.
Thank you. Ms. Cantu, where do you work?
Estancia Villas.
And what is your position there at Estancia Villas?
I am the resident services manager too. So
Okay.
an assistant manager.
So you're appearing
Okay,
as
that kind of broke up for me a little bit. I'm so sorry. Can you repeat your answer?
The resident services manager too.
Ms. Cantu, you're appearing as authorized representative of Estancia Villas LLC.
Yes,
Are you familiar with the tenancy of Mr. Alan Wee?
yes,
Does he reside at
yes,
and that address is in precinct 3 of Travis County, Texas?
yes.
Is Mr. Way's tenancy there at the premises based upon a written lease agreement?
Yes.
Ms. Cantu, I have forwarded over to you and provided to the court Plaintiff's Exhibit 1. Your Honor, would you like me to share my screen?
I think that would be helpful so that Mr. Wade knows what exhibit you have marked as 1 and so forth. I don't know if he's reviewed the box folder or not, so it might be helpful just to make sure we're all on the same page of what document you're asking her about. So yes, please do so.
Ms. Cantu, do you see my screen?
Yes,
Okay. Is this a true and correct copy of the lease agreement between Alan Way and the plaintiff in this case?
yes,
And is this agreement signed?
yes.
Has this been amended, modified, or changed in any way, but for my marking of Plaintiff's Exhibit 1 and the highlighting?
No,
Your Honor, we're going to offer Plaintiff's 1.
Mr. Wade, do you have any legal objection to plaintiff's exhibit number 1? I'm asking if there's a legal reason why I can't admit that document into evidence.
No, that's 100% acceptable.
Okay. Plaintiff's exhibit number 1 is admitted.
Ms. Cantu, pursuant to Box C of the lease agreement, what is Mr. Way's monthly rent?
$1,356.
Okay. Did Mr. Way fail to pay rent in violation of paragraph 3 and 3.5 of the lease beginning September 1 of 2023?
Yes,
Has Mr. Way paid any rent to the property for the month of September 2023, October 2023, November 2023, December 2023, or January or February 2024?
no,
Is the failure to pay rent a default of lease under paragraph 23.1A?
yes,
And does the default of lease entitle Estancia Villas to possession of the premises?
yes,
Are you seeking an award here today of back due rent?
yes,
Are you seeking an award of back due rent of $1,356 for each of the months of September 2023 through February 2024 for a total amount of $8,136?
yes,
Now, pursuant to paragraph 23.5, are you also seeking Estancia Villas reasonable and necessary attorney's fees here today?
yes,
Are you seeking your costs of court and interest at 8.5% on any judgment that would be rendered?
yes,
Okay. Now, Ms. Cantu, moving back up to page 1 of this lease. So Mr. Ways moved into the premises sometime in August of 2023, correct?
yes,
Were you working at the property during that time?
yes, I was.
Okay. And here, as you'll see, the owner on this lease agreement is Steadfast Estancia VDS LLC. Is that right?
Yes,
Did that entity sell the property to the plaintiff, Estancia Villas LLC?
Yes,
Okay. Ms. Cantu, I've pulled up what's marked as Plaintiff's Exhibit 2. Do you recognize this document?
yes,
Is this a true and correct copy of the deed showing Estancia Villas LLC's ownership of the property?
yes.
Your Honor, we're going to offer plaintiffs too.
Is there any legal objection, Mr. Way, to the deed?
Nah, yeah, they own it temporarily.
Do you have any objection to the document coming into evidence?
I do not.
All right, it's admitted.
Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 3. Do you recognize this document?
Yes, they do.
Is this a true and correct copy of the notice to vacate that was delivered to Mr. Way on September 21 of 2023?
Yes.
And Ms. Cantu, how did you deliver this notice to vacate?
I delivered it. I went to his apartment to deliver it. Typically, I put them inside the door and tape them. He was actually home and his door was cracked open. So I knocked on his door and he came and was on the phone and I hand delivered it to him.
Okay, so you hand delivered it to him at the premises?
Yes.
Okay. Has this document been amended or modified in any way but for my marking of Plaintiff's Exhibit 3?
No.
Your Honor, we offer Plaintiffs 3.
Mr. Way, any legal objection to this document?
Yes.
What is your legal objection to the admission of the document to evidence?
Who is Amanda Cantu?
No, that's not a legal objection to exhibit number 3. The question I'm asking is there a legal reason why the document that's marked as plaintiff's exhibit number 3 can't come into evidence? Does it violate?
Oh, no, yeah, go ahead. Put that in. Yeah, that's all you.
All right, so plaintiff's exhibit number 3 is admitted.
Ms. Cantu, this gave Mr. Way through September 21, 2023 to vacate. Did Mr. Way vacate the premises?
He did not. I believe it was October 2020.
Oh, I'm sorry. You're correct. So this gave him.
I'm sorry. Can you repeat that answer for me?
He was supposed to vacate by October 21 and he did not.
So, Ms. Cantu, because he did not vacate the premises, you proceeded with filing an eviction suit. Is that correct?
Yes, correct.
Okay. Ms. Cantu, have you also had other issues with Mr. Way at the property?
Yes, we've had multiple issues with Mr. Way. He has made multiple interruptions to our operations, basically, during business hours. He's made multiple just inappropriate accusations and lies about staff members of UDO and Estancia Villas. He's been very harassing to the staff. He's also made other community members feel very uncomfortable. I personally have moved. I was living in the same building as Mr. Way, just downstairs. And I have just moved out due to my own safety needs and my son's. I have a child. And I no longer felt it was a safe space for us, which is honestly very sad because I've lived here over 2 years. And for that to be the reason I no longer feel safe here, not alone at home, but also in work, is very upsetting.
Okay.
And I say the same for other members of the staff. None of us feel safe with here.
Okay. Are you aware of an incident that occurred on January 3 of 2024?
So let me interrupt here by saying that unless any of these other allegations are related to the reasons for eviction, I'm going to rule them out of order.
Your Honor, they are. We have pled.
Are they pled in your petition? Because I understood you were asking for non-payment of rent, a judgment, and
yes, Your Honor.
insurance.
This was originally filed as a non-payment of rent case. However, our supplemental pleading, we have added other defaults of lease concerning Mr. Way's behavior.
As long as they're in your pleadings, because if they're not in
Your
your
Honor.
pleadings, I don't think it's appropriate for us to entertain them. Okay,
I
go
understand,
ahead.
Your Honor, and I apologize for not being clear in my opening, but yes, we do have other reasons for default of lease here, and they
All
are
right.
planned.
Okay, go ahead.
Ms. Cantu, do you recall an incident that occurred on January 3 of 2024?
I actually think it was January 5th, but yeah, if you're referring to the arrest, I do.
Okay, and you just mentioned an arrest. Was Mr. Way arrested at the property in January of 2024?
He was.
Okay. Sorry, pulling up my screen. Ms. Cantu, do you see my screen here?
Yes.
I've pulled up what's marked as Plaintiff's Exhibit 4. Do you recognize this document?
Yes.
Is this a true and correct copy of an affidavit for arrest against the defendant, Mr. Way, concerning a harassment charge here in Travis County?
Yes.
Okay. Your Honor, we're going to ask that the court admit the affidavit for arrest into evidence.
Mr. Way, is there a legal reason why I can't accept this one?
Yeah, it's an ongoing case. It's an active case.
So that's not a legal objection to the document itself. I take your
Perfect.
point. I take your
Perfect.
point. I take your point that it may not be, shouldn't maybe give it a whole lot of weight, but I think your objection, to the extent that you're making one, is to the weight that I give that document, not to whether or not it's actually admissible. So I will overrule your objection, admit the document, but I will give it only the weight that I think it deserves. For petitioners or plaintiff's exhibit number 4 is admitted.
So, Ms. Cantu, is there other bases for terminating Mr. Way's tenancy other than the non-payment of rent?
Other violations of his lease contract, disturbing the comfort of others, disturbing the comfort of the business, criminal conduct.
Okay. And so what you're referencing here, and I pulled up Plaintiff's Exhibit 1 again, is paragraph 11.1 of the lease agreement.
Yes.
Okay. And you'll see here 11.1 specifically prohibits tenants from engaging in criminal conduct. Is that correct?
Yes.
Okay. Now, pursuant to paragraph 23.1B is a default of lease for a tenant to engage in a violation of the lease and or a violation of any criminal laws.
Yes.
So this is another basis for the property seeking possession of the property, correct?
Yes.
Okay. Ms. Cantu, I pulled up what's marked as Plaintiff's Exhibit 5. Do you recognize this document?
Yes, I do.
Is this a true and correct copy of the resident charges and payments ledger for Mr. Way there at Estancia Villas?
Yes.
Okay. And does this document indicate that no payments have been made on Mr. Way's account beginning September 1 of 2023?
Yes.
Okay.
No payments have been.
Okay. How much has Mr. Way actually deposited or paid to the property since he moved into the premises?
Let me just clarify before you answer that question, ma'am. If you know the answer from your memory without reference to this document, you can answer it. But since the document has not yet been admitted, I don't want you to testify from the document. You can offer it at this time if you wish, but
Your Honor, we offer Plaintiff's Exhibit 5.
Is there any legal objection to this document, Mr. Way?
Yes.
What is your legal objection?
My legal objection is it's inaccurate.
That's not a legal objection. That really, again, goes to the way you can cross-examine her on it and point out any inaccuracies, but that wouldn't prevent it from coming in. That might.
Absolutely.
Does that make sense? Okay.
It sure does.
All right. Then that objection's overruled. Plaintiff's Exhibit number 5 is admitted, but I'll just point out that Mr. Way has an opportunity to cross-examine and offer his own evidence in connection with this document. Go ahead.
Ms. Cantu, how much has Mr. Way paid the property?
I believe it's 720, but also a deposit, or 720.
I'm sorry, I didn't understand. Your audio broke up for me. Could you repeat your answer, please?
$720.
So Ms. Cantu, since the beginning of his tenancy on or about August 23 of 2023, Mr. Way has only paid $720 to the property. Is that correct?
That is correct.
Okay. Ms. Cantu, Mr. Way is still in possession of the property, right?
Yes.
Okay. Ms. Cantu, that's all the questions I have. Your Honor, I pass the witness.
All right, Mr. Way, now is your opportunity to ask Ms. Cantu questions that relate only to the issues in the case.
Yes.
And just as a reminder for us all, just question and answer. So this is not your opportunity to testify. You'll have that opportunity later. Just
Okay.
question and answer.
All right. So why then did you guys write amount claimed as of November 1st to be the exact amount that I needed? Because rent was paid for me.
I'm sorry. I don't understand what you mean by the amount that I needed. So can you
Yes,
just
I
clarify
comprehend.
Go ahead.
Oh, yes, ma'am. So on the original petition, there is an amount claimed as of the date that you filed the petition. Why then is there a balance that doesn't reflect that?
If you're referring to the eviction petition, we will list the amount that is owed at that time of filing the eviction.
You're not understanding my question. And I'll show you the exhibit. The exhibit says the amount claimed as of that time, which you
Mr.
filed
Way.
November 1st. Amanda
Mr. Way?
Cantu. Yes,
Mr.
ma'am.
Way, what you're doing is offering a statement, which is your testimony, right? But we're not at that stage yet. No, you made a statement. You've got to ask her a question. So you could, for example, say, on such and such a day, how much did I owe? And if that's a different number than that's on the document, then your follow-up question could be, well, why is that number different than what's on exhibit 2 or whatever, right?
Okay.
You can
On
break
November
it down
1st.
that way, but you
On
can't
November-
just sort of. Does that
On
make some
November
sense?
1st, Amanda Cantu, on November 1st, how much rent did I owe at the time you filed the petition?
On November 1st, your total balance was $4,426.36. That's including rent, utilities.
Okay, copy that. My next question is, why then would you put the amount of rent claimed as of this date of filing is $4,068.00 on a legal document at 5:30 p.m. 11/1.
Your Honor,
I think, let me just make sure I understand the question. I think what I'm asking, Mr. Way, I just want to clarify. The question you're asking is, if you owed $4,400 roughly, why did she only list less than that amount? Is that your question?
Exactly.
You owed more, but she only listed a little less than you actually owed.
And I'm only asking that.
Hang on. No, don't tell me why. Just trying to understand the question. I think what he's asking you, just to clarify, because I was confused a little bit by the question myself. I think what he's asking you is, if he owed more, why'd you put less than what he owed on the documents? I think that's his question. Is that right, sir?
Correct. Yes, ma'am.
That's his question.
At the time
If you
of
owed 4,400, why'd you only put 4,000? That's his question, basically.
Yes, at the time of filing the eviction, we are only evicting for past due rent. We are not evicting for past due water, sewer, any additional fees, late fees. It is only for rent, for being in violation of non-payment of rent.
Wow.
So, Mr. Way, you really just have to ask her a question. You don't get to editorialize. Come on.
I'm sorry. I apologize.
That's all right. I know it's not always easy, but if you would, just ask her another question, please.
Why did you put you're not suing for any unpaid rent or if you were intending to evict me, why would you put there weren't any lease violations? Why would you put you weren't suing for any unpaid rent or any applicable attorney fees on this original petition? Why then did you do all those in that order?
Your Honor, I'm going to object to the question based on relevance. This is a de novo trial in a county court case.
Excuse me. I will sustain the objection. Mr. Way, they can decide as the plaintiff whether to sue you for everything they can under the sun or for only some of the things they can under the sun. They don't have to justify why they only picked one thing when they could have picked 20 things. So it's not really relevant. It's only relevant as to whether or not what they did file is true and accurate. And do they get to win their case based on what they did file, not what they didn't file? So I'll sustain the objection. Next question.
That is it for my questions regarding that witness, Amanda Cantu. And we'll get to the testimony. We'll talk.
Thank you, Mr. Way. Ms. Du Bois, any redirect?
No, Your Honor.
Thank you, Ms. Cantu. You may turn over the microphone to the next witness. Ms. Du Bois, you may call your next witness.
Your Honor, I would just like to briefly call myself for attorney's fees.
You'll raise your right hand. I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may proceed.
My name is Erin Ann Du Bois. I am an attorney, counselor licensed by the Supreme Court of Texas in November of 2016. I practice with Rogers Law Firm here in Central Texas, and my primary area of practice is representing multifamily housing owners and landlords. I have represented numerous clients in matters that were similar to this matter, and I was asked to represent Estancia Villas LLC in this case. I agreed to do so on an hourly basis. I charge $290 per hour. I've kept detailed records of my time and bill my time in tenths of an hour and tasks performed. In this case, I have discussed the facts of Mr. Way's tenancy with my client's representatives. On several occasions, I have reviewed and analyzed the relevant documents in this case, the ledger, lease, notice to vacate, the deed. I have drafted the supplemental pleading in this case, as well as the notice of rent default. I have reviewed and analyzed the relevant statutory provisions. I have reviewed Mr. Way's multiple filings in this case. I have prepared to conduct this trial and now tried this case. In my opinion, the tasks I have performed have been usual and customary. I'm familiar with the guidelines set forth by the Supreme Court of Texas on behalf of Estancia Villas. Would be an additional sum of $5,000 in attorney's fees. Your Honor, I have provided to the court Plaintiff's Exhibit 6. This has been uploaded onto Box. This is a true and correct copy of my activities export with Rogers Law Firm, showing the work that's been done on this case. Prior to trial today, Your Honor, I have spent 8.9 hours of time on the case, and that was for a total sum of $2,417, and we are just asking for additional sums through trial today for that $2,600. And I'd ask that Plaintiff's Exhibit 6 be offered.
Can you share your screen so that Mr. Way has a sense of what you're referring to when you refer to Plaintiff's Exhibit 6, just in case he hasn't seen it in the box folder? This is her activities report related to the work she's performed. Mr. Way, do you have any legal objection to Plaintiff's Exhibit number 6?
Legal objections, let me see. Yeah, I really think that's inadmissible seeing as the original petition, but if that's not a legal objection, then carry on.
I'll overrule that objection because this is a trial de novo and they get to essentially have a new trial on their claims, and they've included a request for attorney's fees in that claim. So I'll overrule that objection and admit petitioner's Exhibit number 6.
So when did we get to a de novo trial? Well, I'll get to my turn. I'm sorry.
When you appeal from the Justice Court decision, when you go from JP court to county court, in county court, you get a new trial. That's the way it works. Evictions, the Justice of the Peace Court has what we call exclusive jurisdiction, which means every eviction has to start in JP court. Can't file it in any other kind of court, has to be filed in JP court. from JP court, the justice court, any appeal for an eviction from that court then goes to the county court at law. And if there's an appeal from the county court at law, that goes to the third court of appeals. If it's in Travis County, goes to the intermediate court of appeals, from there to the Supreme Court. So that's the sequence of review that you get. Start in JP court, then you get to county court. When you go from JP court to county court, it's a new trial. When you go from county court to the next appellate court, you don't get a new trial unless they order one. You just get an appellate review at that stage. So that's the difference. All right. Anything further, Mr. Boy, or do you rest?
Plaintiff rests, Your Honor.
All right, Mr. Way, it's now your opportunity to call any witnesses or offer any documents into evidence, and you may call your first witness at this time.
Yeah, my first witness, I would like to call Jennifer Alvarado.
All right, Ms. Alvarado, if you would get closer to that microphone, please, and raise your right hand, I'll swear you in. Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
State your name for the record, please.
Jennifer Alvarado.
All right, Mr. Way, you may ask your first question. Go ahead.
The first question I have to ask is, why would you tell me your name was Amanda Cantu? They've been having me under the impression.
Mr. Way, just question, answer. Question, answer. When it's your turn to testify, you can tell me more, but right now, just question and answer.
I apologize.
No worries. Go ahead, Ms. Alvarado.
Your Honor, I'm going to object based on relevance. There's
Well,
no.
it might or might not be relevant given Ms. Cantu's statement that she hand delivered something to him. So it might be relevant. It might not be relevant. I can't tell yet. I will overrule the objection. You may answer the question if you can.
I have never stated my name as Amanda Cantu.
Next question.
No witness.
That's not a question. You have to ask her a question.
No, I was saying that was it for the witnesses.
Oh, you said no witness. Oh, you mean you passed the witness? You okay? I don't think he has any other questions for Ms. Alvarado. Ms. Du Bois, do you?
No.
I just got to speak, apparently.
Okay. All right. Thank you, ma'am. You may step down and you all may mute your microphone. Okay, Mr. Way, you may call your next witness.
Okay, that's it for the witnesses. I apologize.
So you don't have any other witnesses that you want to call? Did you want to offer testimony yourself?
Absolutely.
Okay.
Absolutely.
Well, if you'll turn your video camera back on. There you go.
Oh, sorry. I didn't know it was on.
That's all right. It just went off for just a second there.
Okay.
If you'll raise your right hand, I'll swear you in.
All right.
Do you solemnly swear or affirm under the penalty of perjury that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
State your name for the record, please.
My name is Alan Way, representing myself pro se in this case.
And your last name is spelled W-E-A-H, correct?
Yes, ma'am.
All right, very good. Now, Mr. Way, let me just point out a couple things just as we get started. Because you're representing yourself and you're acting as your own lawyer, it would be a little silly for you to ask yourself a question and then answer it. That really wouldn't make any sense. So because of that, you'll be allowed to testify in what we call the narrative form, meaning you don't have to ask yourself a question and then answer it. You just get to give me the information. Okay. However, couple things to keep in mind. One, if Ms. Du Bois raises an objection, you'll know that because she's going to say objection, right? Or if I interrupt you, I need you to stop your testimony until I can deal with whatever reason I might have interrupted you or whatever reason Ms. Du Bois wants to raise her objection. So at that point, I need you to stop your testimony till we can deal with those interruptions, and then you can be allowed to proceed. Does that make sense?
Absolutely.
All right, one other thing couple other things to remember. One is you tend to talk pretty fast, and
Sure do.
in order to be respectful to our court reporter who's trying to take down a clear record, I'd ask you to slow down a little bit so that she can get everything you're saying onto our record. Okay?
Gotcha.
Last thing is I need you to stay focused only on the issues that are before the court and not on things that I don't have jurisdiction to deal with or can't handle. So right now it's kind of simple what we're doing, but I want you to be able to tell me your story because I know you have a story to tell and I want to hear it, but I want you to do it. I want you to do it slowly enough that we can hear it. And don't forget to let me deal with these objections. The final thing I want to point out is that we've been going a while, and given the pace of everybody's speech pattern, I'm going to have to give Ms. Duet a break here shortly. So probably in about 15 minutes or so, if she can hang on that long. Looks like she can. All right, good. She's telling me she can go another 15 minutes. I'm going to break at about 9:15-ish. And then we'll take about a 10-minute break, and then we'll come back and finish up whatever we haven't finished by then. But I've got to give her a rest at some point since we've been at it for over an hour. Okay. All right. Mr. Way, you may proceed now with your direct examination.
Yeah.
And then following that, Mr. Boyd will have an opportunity to ask you some questions on cross-examination. But for now, we'll start with your direct examination, and you may proceed.
Yeah, I wanted to start with when I moved in. The first thing that happened was I moved in and signed the lease and everything like that. I checked out building 4. Long story short, they ended up moving me to building 6. It's on the clubhouse camera. When I met Amanda, she gave me her card with her name on it, and it said Amanda Cantu. That's documented. I've asked for subpoenas. I've asked for 4 subpoenas in order to get the information in this case, because that's actually relevant now. Because Amanda Cantu said she delivered a notice to vacate, and she hand delivered it to me, which technically was Jennifer Alvarado. If that makes any sense. Okay, so
I understand what you're saying. Keep going.
Yeah. So basically, they evicted me. I had moved into the apartment, I think August 21st. September shows up, UDR, like some sort of billion-dollar corporation, comes in and buys out this place. They upgrade the locks, do a bunch of smart locks. Long story short, I'm on camera right now. Every aspect of my life is on camera. Irrespective of that, you could just look at the original petition. The original petition itself does not give any merit to even have the trial. Because 1, they had all the money at that point in time, signed and date stamped, and then they weren't suing for anything. I hadn't violated the lease or I hadn't done anything. There was 0 cause to even evict me. The only outlet that I would have is to appeal the eviction. To make any sense, if I wanted to stay there, I would have to appeal the eviction. So as of November 1st.
But may I just ask a clarifying question? The testimony in the record so far from the plaintiff is that you were to pay $1,356 per month. And that to date, you've only paid $720. So when you say you didn't owe any money, I'm confused by that. Could you explain? You explain to me the dollar amounts? And if you could, we're going to take a break here in a minute. If you don't mind waiting to enjoy your breakfast or snack or whatever you're eating, if you could wait and do that until we take our break, that would be really, really helpful to me. So if you. I need you to clarify. You're saying you didn't owe them any money. They're saying you never paid even a full month's rent. Could you just help me understand that?
So what's the amount? 1,300 and what? 56?
I believe the testimony in the record is $1,356 per month.
So that's September, October, November, right? Okay, so that 1,356 multiplied by September, October, November equates to $4,068. If you go back to the original petition, this is what I'm trying to argue here. They literally have the document signed by an authorized representative stating the amount of rent claimed as of this date of filing is $4,068.00. My thing that I'm saying is essentially there was no cause, there was no merit to evict me because they had rent. They said they claimed it on my behalf. They're not suing for anything. I haven't broken any violations or any lease. It is literally the reason why we're here right now. There's no other option for me if I wanted to keep my location other than to appeal.
Here's what I'm asking though, Mr. Ray, for clarification. They're telling me that you owe $1,356 a month.
Yes.
And that you have only paid $720.
No, incorrect.
Okay, that's what I'm asking you to tell me. So they're saying they're saying you owe $1,356 every month. You owed it in September. You owed it in October. You owed it in November. And they're telling me in all that, they're telling me in all that time, you've only paid $720. So I need you to help me understand The
No.
payments that you've made. Can you talk to me
Gotcha.
about that?
Okay, so on November 1st, at 5:25 p.m., there was $4,068 paid on my behalf to Estancia Villas, period. In addition to that, that's not even accurate because my deposit in conjunction with the August month adds an additional $720. So in reality, it's actually
Hold on. When you say that a sum of $4,068 was paid on your behalf, can you tell me
Yes.
more about that? Who paid it? Where's the check? Tell me more about the payment and so forth.
The managers paid it for me because they've been monitoring me. They've been putting me on camera. They've been putting me on camera and circulating my information. There's a bunch of nonsense going on here. And that's what the payment was for.
So hang on a second. When you say that the managers paid it for you, tell me more
Yes.
about that. Who
Yes.
paid it? How did they pay it?
Jennifer Alvarado. It doesn't matter. It was electronically paid for me. It was taken care of on my behalf for me. They have it documented here, time and date stamp.
Why would the managers pay your rent for you?
Thank you. Because they have some organization going on here where they're trying to demasculize men. And as soon as I stepped foot in here, ever since then, it's been a whole campaign to separate my genitals from me. It sounds ludicrous, but there's there's visual communications, there's emotion of continuance. You guys are treating this trial like it's just some sort of eviction, copy, paste, cut, paste, and that's it. There's so much information in here.
Okay, hang on.
That's why it was paid. That's why it was paid for me.
Okay, so hold on. So let me just back up because I want to do this in sort of pieces that I can understand and we get a clear record.
For sure.
If I understand what you're telling me that on November 1 at 5:25 in the afternoon on that day, Ms. Alvarado, on behalf of Estancia or on behalf of herself?
Nope, I'm saying prior to that date, right? It doesn't matter if she says she's gonna pay it for me, it doesn't matter. Prior to that date, it was paid. It was paid on my behalf for that reason exclusively. Me being on camera inside my location.
Okay, so let me just be clear. Do you know in what way money changed hands from Ms. Alvarado or anybody else on your behalf to pay your rent? Can you tell me more about how that payment was made? Tell me what you know about that other than what somebody may have told you. I don't want you to tell me what they told you so much as I want you to tell me what you know happened, if you do.
Management paid my rent prior to that date. It's on it's a legal document right here.
How do you know they paid your rent?
Because they told me that they would. I've been on camera. They've been circulating my information on social media, laughing at me, putting me.
Who told you that they paid it? Who told you that?
The manager, Jennifer Alvarado told me that she paid it. The manager.
Okay. So let me just be clear.
Prior to that date right there. It was paid on my behalf.
Okay, let me be clear. Let me be clear. Your testimony today is that on or before November 1st, $4,068, the $4,068 that you owed in rent to that date was paid on your behalf by the manager of Estancia Villas, Ms. Alvarado.
UDR essentially, but through her as an authorized agent. UDR essentially, but through her as an authorized agent.
All right. So they paid your testimony is that Ms. Alvarado on behalf of her employer paid your rent for you.
They wanted me to leave is why they put that number down there. So they paid the rent to have me leave. That's what that was about.
Okay. All right.
And the reason why, and I'm still in the testimony if I'm okay to continue.
Yes, you may continue.
Okay. The reason why that number is down there is because I've been monitored. They've installed smart locks out here and they have access to my codes. On the inside of this door, I have have the ability to lock the door and prevent anybody from coming inside here. When I exit and I go to the outside of the door, it's an electronic code. When I leave, these guys have me on GPS. I come back inside, my stuff's all over the place. They're setting up spy cameras and all kinds of nonsense and circulating my information. Estancia Villas in general. And when I mentioned that thing about them trying to separate my genitals from me, not physically, but they've been doing all kinds of psychological tactics to do so, like messing around. And I have the visual communications. First and foremost, let me go ahead and reiterate that this was supposed to be a jury trial. The fact that you guys are trying to consolidate the trial, they've been doing so many things to just shut me up, put me in jail. I literally started submitting exhibits to the case. As soon as I submitted an exhibit to the case, here comes an interception from Travis County Sheriff's Office and Travis County Civil Division as if I did anything wrong. We're literally in an ongoing dispute and these guys come in and intercept. This is a massive case I was trying to exhibit here. The first thing I gotta say is, just on the merits of the original petition, like they do not have cause to evict me. Like I said, it was paid on my behalf. That's how much they collected. It was the exact amount. And now look, they don't even have a lease violation. They don't have a holdover. They don't have anything for applicable attorney fees. And it's because I know what I know. The reason for the countersuit was because I wanted to relay what I know. You guys were trying to separate it and do all kinds of stuff. The way that they moved about this was absolutely, they shouldn't even process this case. The first thing they should have said was, hey, this dude didn't even do it. What are you trying to evict this dude for? And if I would have co-signed it, then they would have permission, but I didn't. So here we are.
Let me stop you there. Let me stop you there to ask another clarifying question. Since you take the position that your rent has been paid through November, right? All right. So can you tell me what amount of sums have been paid by you for the months December 2023, January 2024, and February 2024? Have you made any rent payments as required under the lease agreement for the months of December 2023, January 2024, or February 2024?
No. And the reason why, if I'm still inside my testimony, is because with them only suing for the right of possession, and this was told to me by the JP courts, I have documentation of my statement of inability to pay. It literally says, so I've been able to not pay rent. They didn't sue me for anything. That literally prompted me not, they just took my statement of inability to pay. So essentially, I don't owe anything to the JP court and I don't owe anything going forward until we come to trial.
Let me stop you there.
And let me find the document. I'm sorry.
My question was simply whether or not you paid rent. Your position is that your rent was paid through November, that someone paid it on your behalf. That's what you told me. And if that's true, then the question is, on December 1, did you pay rent? Did you pay rent to them?
Okay. Well, on December 1, I did not give any money to JP Court.
Okay, hold on. Mr. Way, stop. I'm still trying to get to the sort of clarifying question I'm trying to ask. So if I understand correctly, you think your rent was paid through November. And so I understand that. If that's true, then the next point in time in which you would have owed rent would have been December of 2023. And if I understand your testimony, you did not make a payment of rent in December of 2023. Is that right?
No, I did not. Can I continue with the testimony?
Hang on. I'm trying to clarify what you said about the payments.
Yes, ma'am.
Okay. So you didn't pay in December, you didn't pay in January, you didn't pay in February, correct?
It was paid.
Right?
I had a zero balance in in December, January, February, and anything beyond that, I have a zero balance. So technically,
okay, wait,
I did pay.
Stop. I'm asking about things you actually did, not your legal theories. That's why I'm trying to back up and clarify. You're giving me your sort of legal theory about why you owed or didn't owe something. That's not my question.
I got you.
I'm asking a very simple factual question. Did you make a payment of $1,356 to Estancia Villas in December 2023? Yes or no?
I paid $0 to Estancia Villas in December 2023.
Okay.
As far as December?
No. Just getting some facts here. In January 2024, did you make a payment to Estancia Villas in the amount of $1,356? Yes or no?
No.
Okay. And in February 2024, did you make a payment of $1,356 to Estancia Villas? Yes or no?
No.
Okay. Now, next question. The affidavit of inability to pay. That is a document that you filed in the court file, correct?
Yes.
Okay. I just wanted to make sure factually I understood what you were saying. Now you can continue with your testimony.
Sorry. Yes. So basically with that statement of inability to pay, they had a cash surety balance of like $277. And this is why I'm actually suing JP3 too, because they had a cash surety of $2,700, which basically I substituted with that statement of inability to pay. And it is co-opt with the fact that they only sued for right of possession prompted me to only owe $0.00 going forward, confirmed by JP Court. And I have the documents to prove it. So technically, the original petition, I didn't owe any money, and then Estancia Villa accepted it. They co-signed it. They had the opportunity to say no. They accepted it. They signed off on it. I have that too. Now, going forward into the new trial here, my stuff was accepted as far as me not being able to pay. So we have the initial petition, irrelevant. Moving forward to the new trial, I'm not paying for December, January, February, or anything beyond because they only sued for right of possession. Here we are in court to argue about the merits of the case. That's why prior to this moment in time, they did not get any money from me between the points of right now and December 1st.
This is really helpful. I think there may be some
Let me
misunderstanding.
find that document. Sorry.
Yeah, I think there may be some misunderstanding of what things mean that are filed. For example, the affidavit of inability to pay does not mean you don't have to pay your rent, for example. No. That's not what it means.
That's not what I'm saying.
But I understand. I think I understand a little better about sort of how we got where we are, and this has been really helpful. I'm going to let you go ahead and finish up with your testimony because now I got a better sense. And we'll get a little farther, and then we're going to have to take a break to give the court reporter a rest.
Oh, for sure.
Go ahead.
Yes, ma'am. So, yeah, that statement of inability. And then so on top of that, I essentially countersued because I was then aware of the nonsense that was going on. It's so disgusting. And if you guys, or you don't have the power to process that case, it really doesn't matter. These guys are talking about an eviction appeal as though like, this isn't the biggest news. This is very big. So I just want you guys to know, independent of that, like there will be suits. But if we can escalate to a higher,
don't tell me, don't stop. I gotta keep you focused on this case, these merits.
Okay.
It's the same thing I told Mr. Boyd before she told me she had pleadings about other things. Same thing. Just focus on what we're here about today. You have a right.
I guess let me just reiterate everything then. First, on video in the clubhouse when I first arrived, Amanda Cantu, or who I thought is technically Jennifer Alvarado right now, handed me a card. And on that card, it said Amanda Cantu. From that point when I initially got here till now, or just about a week ago when she told me, oh, I'm actually Jennifer. Like I was under the impression, and I would call too, and can I talk to Jennifer? Then they would transfer her.
Your Honor, I'm going to object based on relevance. I have no idea how this has anything to do with the claims.
Because of the notice to vacate. Because of the notice to vacate. Who served it to me?
Mr. Way? Mr. Way?
Sorry.
I'm gonna sustain her objection because the notice to vacate, which is in evidence, doesn't really matter who handed it to you. It matters that you received it. So she's correct. And we can move on from there. Go ahead.
And it's also relevant because imagine having
we're not going to argue that. No, stop.
Yeah.
We're going to move on past that. Go ahead.
Okay, 10-4. So they said incorrect names, whatever. I was under that impression. Now back to the original petition. Again, they have the amount. Literally, it says the amount claimed.
Your Honor, I'm going to object. I'm going to object again based on relevance.
Stop.
I'm just trying to summarize.
No, yeah. So I'm going to overrule Ms. Du Bois' objection, but I'm going to ask you not to reiterate because that's really just repetitious.
Okay.
Everybody's been listening all morning, certainly me.
Perfect.
We have a record. I don't need you to summarize. I don't need you to summarize or reiterate. I need you to tell me something you've not already told me.
Okay. So you've already gotten the portion of me not owing rent because of the
you don't need to summarize. You don't need to summarize.
Okay.
Keep going. If there's anything else, keep going.
I'm just thinking.
No, take your time. I'll tell you what, let's take our break round. That way you can give time. You have some time.
Yes, the juice is flowing, right?
Yeah, well, organize your thoughts, I was thinking.
Yes, ma'am.
All right, let's give our court reporter and everybody else a comfort break. It's 9:25 by my watch. Let's take 10 minutes and we'll resume at 9:35.
Judge, it's 11:25, Judge.
Sorry. 11:25, we'll resume at 11:30. I'm looking.
What the heck? That was so interesting. Bitch lying and I move and I fucking move. Bitch, you got cancer. Die. Stupid ass. You sitting there lying, you know, bitch, you told me your name was Amanda. Tell me how much of a fucking lie that is. You're under your fucking original petition, you're lying. All kinds of shit. The statement of inability to pay, you changed this shit. Stupid. Let me go. I think it's events prior. Exhibits events prior. There we go. What a fucking idiot. You can tell by her body language too. Her body language, she's just looking all over the place and I can't believe I gotta say this and I'm such a liar. Like, what the fuck? And I'm gonna appeal that shit. Fuck with me. Stupid ass. That shit's annoying because I can't. And I move, and you're trying to make me look like a bad person, but I'm like, what the fuck? Yeah, and I'm getting back to my trial, bro. And I fucking got a job and got arrested. That's what the next part you need to talk about. Yes, that's the next thing you need to talk about. He said, yeah, so I basically got arrested and they followed suit and decided to do all this nonsense, but all my shit's on file. You can't reset the trial, bitch. He said the shit literally says that you fucking paid. Perfect. You got the documents. I didn't even share that shit. I didn't even share that shit. You put my shit over there and then Travis County intercepted, bro. I'm glad I said that shit, bro. Fuck out of here. Stupid ass. You're doing all this nasty shit, all this weird shit. That's why the fuck it was paid for me because I know this information. Stupid ass. Did you not look at my documents on file? Just trying to lie and trying to make me seem like I'm bad. And this dude's coming over here and he's doing this and he's gonna arrest it. Did you look at the documents, you fucking idiot? Yeah, bro. I haven't even talked about the simulation yet. Yeah, they said she moved. Thank God. You're the one raping your kids. And they're just making me say it. And I've been doing it. I'm telling you, they've been fucking putting cameras in my shit. And you know it's true. Circulating my fucking information. What the fuck do you have to say about that? I'm gonna peel the fuck out of that watch. Okay, so you need to talk about the jury demand, and then you need to talk about you need to show your documents, bro. Whew, let's go. I'm not even done. I'm not even done on my statement, bro. You say here goes, can I share my screen? Here goes the documents. Well, I wasn't paying that because they accepted my statement of inability to pay. They said I wouldn't need to pay these until the day before fucking county. Until fucking trial. That's what they told me. And then on top of that, I had then asked for any so what's it called, trial? And they just denied it. Woo! You got on a few things here. That case didn't even have a fucking answer. Why did you put that on the fucking petition? Stupid. Try to get rid of it. Ain't nobody likes me. Bitch, you're just saying shit. I'm pretty sure everybody likes me right now. I don't care if they don't. Stupid ass. You mad that your children are getting fucked and doing all kinds of nasty shit, and you want to be mad that I fucking know about it. And I'm trying to fucking figure out how to tell people about it. And you're asking me everything to fucking lie and steal. Ooh, I can't wait. I cannot wait. I cannot wait. Go back in. And you're talking so fast. Bitch, fucking process faster. I guess that lady does have to jot down everything I'm saying. But I keep getting interrupted. He said, I have a motion of continuance. He said, I'm not having a fair trial. I have multiple documents on how to have my subpoenas on, none of this shit. You're not looking at demand trial, they're not looking at nothing. You know what I'm saying? There's been a demand on there. Get back to your demand, bro. Your demand for a jury, take notes. Demand for a jury trial. Tenant's notice of appeal for rent payment. Perfect. That's the next one you need to show right there. Yep. And then your fucking notice for rent. For your demand. Your jury trial for demand. Yeah. Yeah. I countershoot them and then I put a fucking demand on there. And then don't let that slide, bro. Don't let that shit slide. Don't let the demand slide. You know what I'm saying? And don't let the fucking why I'm not paying rent. Like I didn't pay rent because we had everything. You know what I'm saying? And then after I didn't pay rent, it's because I didn't owe anything. You know what I'm saying? So then here we are for trial. I asked for a jury trial. Why the fuck are we here? I've been asked for a demand for a jury trial. I'm not playing no games. And I'm gonna show them too. And then don't forget to tell how Aaron is lying and doing a bunch of stuff that's literally against the fucking. Ooh, and I'm gonna tell them too the date. The date. Yes, thank you. Date of. Perfect. That bitch gonna try and make me look bad. Well, you try to make us look bad, bitch. Ain't nobody care about you. You're ugly as fuck anyways. And hold on. Don't even do it, bro. Body language is so bro, you can read niggas. That bitch doesn't even want to say that shit. That's so weird. Why are you saying it? What if they actually are like controlled? I just know you bitches is eating dicks. That shit pissed me off just now, bro. I had to raise my voice. Because what the fuck is wrong with you? Damn. I ain't gonna lie, bro. The judge is actually impartial.
This court is back in session.
Oh shit.